First, permission to make appearances for the record.
Of course.
Good morning, my name is Maisha Ishmael, and to my immediate left is Mr. William Rogers,
Good afternoon, Your Honor.
Good afternoon.
and to my far left is Miss Jillian Jaleesa Harris.
Good afternoon, Your Honor.
Good afternoon.
Together, we represent the plaintiff in today's case, Mrs. Andy Park.
Good afternoon.
Good afternoon.
The plaintiff has a few documents to tender to the bench. Okay. First, we have the complaint, the stipulations, the statutes, the pretrial order, the minimum rules of evidence, and available case law for Your Honor's reference. May I approach opposing counsel and tender this evidence to the bench?
You certainly may. Opposing counsel, I trust you've had a chance to review all these documents.
Yes, Your Honor, we're all good.
The plaintiff would like to draw attention to statute 10.56, which is on page 2 of the statute. This statute says that the statements of Jesse Duran and Sidney Park are also considered party opponent statements as well as their parents in today's case.
All right, the court will take notice.
The plaintiff also has another piece of evidence to tender to the bench. This is Exhibit 1, which per the pretrial order has already been authenticated. May I approach the opposing counsel and tender to the bench?
Yes, you may. Thank you.
The plaintiff will also like to invoke Rule 615, which is the constructive sequestration of all witnesses outside of a party representative. Today, the party representative for the plaintiff will be Ms. Andy Park.
Defense, you have a party representative?
Yes, Your Honor. Our party representative today is Ms. Hayden Duran.
Good afternoon, Your Honor.
Good afternoon. All of the witnesses will be sequestered, except the two of them.
And finally, we would like to ask Your Honor's preferences for moving about the well. May we move freely?
Yes, you may move about the well as you see fit. Simply ask permission before you approach opposing counsel, the bench, and an opposing witness.
Yes, Your Honor. With that, the plaintiff is ready to proceed.
Defense?
Yes, Your Honor. First, can you make introductions before the court?
Yes, ma'am.
My name is Isabel Shane, and today, along with my co-counsel, Mr. DeMonte Morgan,
Good afternoon, Your Honor.
Good afternoon.
and Ms. Kathy Lynn,
Good afternoon, Your Honor.
Good afternoon.
will be representing the defendant in today's case, which is Ms. Hayden Duran. Now, at this time, I'd ask permission to approach the bench in order to tender the defendant's answer and also the character evidence sheet that we have signed by both parties.
Any issues?
No, Your Honor.
You may approach.
Now, this time, Your Honor, I would like to turn your attention to the end of our answer, specifically paragraph number 26.
Okay.
Now, this states that the defense will be asserting an affirmative defense today, which means that all plaintiffs' claims are barred by the doctrine of comparative fault, meaning that the harm suffered by Sidney Park is more attributable to the wrongful conduct of the plaintiff than any wrongful conduct from the defendant.
The court will take note. Is there anything further?
With that, we're ready to proceed, Your Honor.
All right. Plaintiff, your opening statement?
Yes, Your Honor. Maisha Ishmael for the plaintiff. May it please the court?
It may.
Your Honor, opposing counsel, members of the jury, Hayden Duran saw the signs and failed to act. Today you're going to hear a story about two 11-year-old children, Sidney Park and Jesse Duran, and how they were playing with a gun on August 18, 2010, and how that ultimately led to the death of Sidney Park on that day. But today's case might be a little different than what you may expect, because we're not here to talk about the children and the decisions that they made. We're here to talk about the parents, Ms. Andy Park, Hayden Duran. I want you to consider something. Consider your family and how you would do anything to protect them. That is what Ms. Andy Park had to consider a few months before this incident. Annie Park's home was broken into, and she had to buy a gun for the sole purpose of protecting her family. Now, the evidence will show that when she bought this gun, she made sure she did all of her research. She researched the gun manufacturer to make sure she bought the most safe gun on the market. She researched the safe manufacturer to make sure she bought the most durable safe she could find. But a few months later, Ms. Park got a phone call that none of us would ever want to receive. She got a phone call while she was at work that told her to come home immediately. And when she got there, she walked into her home and she saw a body on the floor, laying in blood, covered in a white sheet. She knew exactly who it was. It was her daughter. And on August 18, 2010, her daughter was fatally shot by Jesse Durant. Now, today you will learn that Jesse Durant's mother, Hayden Durant, saw all of the warning signs and failed to act. Today you will learn that Jesse's behavior displayed many warning signs. Jesse had an unhealthy interest in guns. Jesse got into multiple physical altercations at school. You will learn that Jesse enjoyed extremely violent video games. And Hayden Durant saw all of these signs and failed to act. You will learn that each and every time Jesse Durant showed Hayden Durant a sign, Hayden Durant did nothing. And that is why today, Ms. Annie Park sits before you, suing Hayden Durant for negligent parental supervision. Now, as the plaintiff today, we bear the burden of proof. We must prove to you by a preponderance of the evidence, which means more likely than not, or 50% in a feather's weight, that Hayden Durant did not do enough to prevent the accident that had happened on August 18th. Now, to prove this to you, we must show you 4 things. 1, Hayden Durant failed to properly warn Jesse about the dangers of guns. 2, Hayden Durant failed to warn the Parks about Jesse's unhealthy interest in guns and violence. 3, that on August 18, 2010, Jesse Durant created an unreasonable risk to Sydney Park on that day. And 4, that was the direct and proximate cause for Sydney Park's death. When we say direct cause, that means but for Hayden Durant's actions, Sydney Park would still be alive today. When we say proximate cause, we mean that Hayden Durant should have foreseen this accident occurring based on Jesse Durant's behavior. Now, to prove this to you, we're going to call 3 witnesses. First, you'll hear from Miss Annie Park. She will come before you and explain why she bought a gun in the first place. She will tell you about the research she did and the steps that she took to try her best to protect her family. She will also tell you about Jesse Durant's behavior and about Jesse Durant's interest in violent video games. Next, you will hear from Dr. Campbell Solo. Now, Dr. Solo is a child psychiatrist, and she will come before you and talk to you about the warning signs Jesse displayed and how Hayden Durant failed to act. Lastly, you will hear from the babysitter, Danny Brooks. Now, Danny Brooks was Sydney Park's babysitter, but also babysat Jesse Durant from time to time. He will talk to you about Jesse's behavior, and he will also tell you that he told Hayden Durant about Jesse's behavior and how Hayden Durant did nothing after he told her this. Hayden Durant saw the signs and failed to act. At the end of today's trial, my co-counsel will come before you and ask that you find Hayden Durant liable. Thank you.
Give us just 1 second. Defense counsel?
May I proceed?
Yes, you may.
Now, Ms. Ishmael just stood before you and told you about the undeniably tragic death of Sydney Park on the morning of August 18, 2010. There are certain parts of that story that Ms. Ishmael didn't tell you. For instance, she didn't tell you that Sydney Park knew that the gun was kept in the safe in the bedroom. And she didn't tell you that the combination to the safe was written down in an unlocked file drawer just a few feet away. But most importantly, Ms. Ishmael forgot to tell you that the gun and the bullets were in the same location. But if I were the plaintiff, I wouldn't tell you these things either. I wouldn't show you how easy it was for the kids to access this weapon. But as the defense will show today, guns without bullets just don't shoot. Now the plaintiff is charging Hayden Durant with negligent parental supervision. In other words, they are alleging that Hayden either knew or should have known of the need to prevent Jesse Durant from harming Sydney, that Hayden failed to exercise reasonable control over Jesse, and that as a result of Hayden Durant's negligence, she is the proximate and direct cause of the death of Sydney Park. As Ms. Ishmael just told you, the plaintiff has to prove these elements by a preponderance of the evidence. In other words, they must show you that it is more likely true than not that Hayden Durant acted negligently, and that Hayden Durant's negligence is the direct and proximate cause of Sydney's death. Now, while the plaintiff has the primary burden, the defense is assuming a burden of our own in affirming an affirmative defense. Now, what this means is that at the end of today's trial, if you feel that the plaintiff has met their burden, if you feel that they have proven these things to you by a preponderance of the evidence, then you must still look at the actions of Andy and Sydney Park. And we expect that those actions will show that the Parks' negligence was equal to or greater than that of Hayden Durant. And it's at this point that you cannot find the defendant liable. And members of the jury, we understand how difficult it is to sit here in court today, to listen to the testimony of a grieving mother, and to consider that she may have had some part in her daughter's death. But today we ask that you separate the emotions from the evidence, and when you do, you will see that guns without bullets just can't shoot. Now, to prove the plaintiff's negligence to you today, we're going to be calling for you several witnesses. First, you're going to hear from Hayden Durant, Jesse's mother. And Ms. Durant is going to tell you that she never kept a firearm in her home, so Jesse had no practical knowledge of how to work this gun. She's going to tell you that despite not having a firearm in her home, she still warned Jesse about the dangers associated with these weapons. But you don't just have to listen to Hayden today, you're also going to get to hear from Jessie Durant herself. Now, as the only person present at the time of the incident, Jessie's going to walk us through step by step by step of how that morning occurred for her. She's going to tell you that at 9 a.m. she went over to the Parks' home to play with her best friend Sydney, and that when the Parks left, she and Sydney were home alone. She's going to tell you that it's at this point that Sydney led her to the combination. And when they got the combination, they went to the safe. Upon opening the safe, there was the gun, there was the bullets. Jesse's going to tell you that they both played with this gun, taking turns. But most importantly, Jesse's going to tell you that it wasn't until Sydney Park tossed a loaded firearm that that gun went off and shot Sydney. And lastly today, you're going to hear from Dr. Ash DeRosa. Now, Dr. DeRosa is a gun safety expert, and he's going to walk us through the proper precautions for keeping a gun safely in the home. Dr. DeRosa is going to tell us that it was the Parks' own gun safety risks that brought us here today. And that is why at the end of today's trial, my co-counsel Kathy Lynn is going to stand before you and ask that you find Hayden Durant not liable. Now, as we go through the course of today's trial, you're going to meet a lot of people, and you're going to hear a lot of contradictory evidence. But let's not forget that the question that brought us here today is not whether a child died, but who left the gun, the bullets, and the safe more accessible to those kids. And we are confident that the more you deliberate upon this question, the more you deliberate upon the law, the more clear the solution will become. Because guns without bullets just don't shoot. Thank you.
All right. Plaintiff, would you like to call your very first witness?
Yes, Your Honor. At this time, the plaintiff calls Ms. Andy Park to the stand.
Ms. Park, you're aware that you were sworn in?
Yes, sir.
May I proceed?
Yes, you may.
Good afternoon.
Good afternoon.
Please introduce yourself to the court, spelling your last name for the record.
My name is Andy Park. It's P-A-R-K.
Tell us a little about yourself, Ms. Park.
After serving 4 years in the Navy, I went back to school and double majored in finance and business administration. I met my husband when I was in college, and when we graduated, we both got a job at the local hospital, and I was the manager there. A few years later, my daughter Sydney was born.
Tell the members of the jury a little more about Sydney.
Sydney was a very smart and talented little girl. She wanted to become an engineer. Later that summer, I had signed her up for Camp Invention, and she was so excited about it. I was just very, very proud of who she was becoming and what she was accomplishing.
When is the last time that you saw your daughter?
It was the morning of August 18th, 2010. I had to go to work that morning, so I kissed her on the forehead and I said goodbye. I told her that I would check in on her, and I also had the neighbor that was going to stop by and check in on her. I didn't know that that was going to be the last time that I would get to say goodbye.
What happened to Sydney?
Sydney was shot. My 11-year-old daughter was shot in the head.
You said that Sydney was shot. To your knowledge, where did the gun come from?
The gun was mine.
Mrs. Park, if you knew your daughter would be in the home, why did you have a gun in the first place?
My husband works out of town a lot of the time, so it was just Sydney and I in the home. And that January, my home had been broken into. I wasn't comfortable, just me and my daughter being in the home alone, so I purchased the gun in order to protect my daughter and I when my husband wasn't there.
How did you store your gun?
I stored my gun the best way that I knew how. And before even buying the gun, I did so much research. I bought the best gun, the most secure safe. I read all of the reviews and all of the statistics, and I stored the combination in a place where I honestly thought no one would find it.
Your Honor, permission to approach opposing counsel with what has been marked as plaintiff's 1 or
Granted.
2, I'm sorry. Permission to approach the witness. Mrs. Park, what did I just hand you?
This is a photo of my filing cabinet.
Is this a fair and accurate copy of a photo of your filing cabinet?
Yes, it is.
And is this where you chose to store your combination?
Yes, it is.
Your Honor, at this time, plaintiff moves to admit plaintiff's 2 into evidence.
Any objections?
None, Your Honor.
It will be admitted.
Mrs. Park, why did you choose to store your combination in that drawer?
Because I'm a business major, I have so many documents in this filing cabinet. I honestly thought that it would be safe there. I didn't label the piece of paper, and I thought it would be okay.
I want to talk about the bullets for your gun. Where did you store them?
They were stored separately from the safe. I always made sure that they were in the garage and not in or near the safe.
Earlier on direct examination, you said that Sydney was shot while you were at work. To your knowledge on that day, was Sydney home alone?
No. Jesse Duran and Sydney, they were going to stay in my home while I was at work and while Jesse's mother was at work.
Now you mentioned Jesse. Who was that?
Jesse was our neighbor.
You mentioned Jesse's mom. Who was Jesse's mom?
Well, I met Jesse's mother, Hayden Duran, in 2004 when I was working at the hospital. And soon we became neighbors. And our children were about the same age, and they grew very close, but they were very, very different children.
What do you mean?
Well, Sydney took after me. She was rather shy and timid. Jesse was just very aggressive.
Why do you say that Jesse was aggressive?
He liked to pretend like he was one of the characters that in one of the violent video games that he would
Objection,
bring
Your Honor,
over.
speculation. I don't know how this witness would have any knowledge about how Jesse, or what Jesse would like to do, particularly pretend.
May I be heard, Your Honor?
Yes, you may.
The foundation has been laid that Jesse Durant will come over and play with Sydney Park on numerous occasions. So this witness is just testifying to what she saw, how Jesse Durant would interact when he was at her house.
Response?
Your Honor, I don't see how this witness could testify to what Jesse was pretending to do as opposed to what Jesse was actually doing.
What was your specific question?
My question, she said that Jesse Durant seemed more aggressive. I said, why did she say that? And that was her answer, that she saw Jesse like to act like characters in the video games that she played.
All right, well, we can hear what the witness herself saw. She can say she saw him pretending to shoot a gun or any of that. She can't say that she saw him pretending that he was a soldier, pretending that he was, Wolverine or some kind of superhero. So she can free to say whatever she saw him do, but not what he was actually pretending to be. So your objection is sustained and overruled in part. You may continue.
Yes, Your Honor. Now, you said Jesse would bring video games to your home. What would you do when Jesse would bring those games over?
I would take them away immediately and store them in the bedside table in my home.
How would Jesse react when you took those video games away?
I had seen temper tantrums before I have a child, but Jesse just threw a fit. He threw himself onto the ground, kicking, screaming. I had never seen anything like it. At one point, things were thrown. It was terrifying.
Did you ever tell Hayden Durant about Jesse's behavior?
Absolutely, yes.
And what did she say?
Really nothing. She brushed it off and said that she would deal with it. And as far as I know, Jesse was never disciplined.
I want to turn your attention to August 18, 2010. How did that day begin for you?
Well, I had work that morning, so I said goodbye to Sydney. The babysitter had called in sick that morning, so I had the neighbor that was going to come in and check on them. But I got in the car and I went to work.
What happened when you went to work?
I had just stepped in the door and I received a phone call.
What phone call?
It was Officer Dale Williams, and he had told me that there had been an incident in my home.
Objection, Your Honor. Hearsay to what Officer Williams told Ms. President.
Response?
Your Honor, we're not using these statements to be offered for the truth of the matter asserted. However, we're using them for the subsequent action of this witness. After she received the phone call, what she did afterwards.
I agree, overruled.
Did Officer Williams tell you what had happened at home?
No, he didn't, and my mind just was absolutely racing at that point. So I hurried home.
When you got home, what did you see?
The whole front of my house was lit up with police cars, and ambulances were there. So I just, sorry. I ran to the door. I was just thinking about Sydney. I was hoping she'd be okay.
And when you ran into your home, what did you see?
The first thing I saw were those pink flip-flops. I had bought them for her on a trip to Cedar Point, and she just loved them. But there they were, poking out from under a white sheet with my daughter's blood, and it was everywhere.
Your Honor, at this time, I have no further questions.
Defense counsel?
Yes, Your Honor. Ms. Park, my name is DeMonte Morgan. I'm counsel for the defense, I just have to ask you a few questions. If you need any moment, just let me know.
Can I have a tissue, please?
Yes. Ms. Park, you are a marksman in the Navy, correct?
I was a clerk. I served as a clerk in the Navy.
So you weren't a marksman.
Oh, I was, but my main job was a clerk.
All right, so as part of your job as a marksman, you were taught how to safely handle a firearm.
That is true. We spent about a week in boot camp on the safety of a firearm.
So you know how important it is to know how to work that firearm for individuals surrounding you.
Absolutely, yeah. So,
Now, Ms. Park, you didn't teach Sydney how to handle that firearm, did you?
I'm sorry?
You didn't teach your daughter Sydney how to handle that firearm?
Oh, she was 11.
Now, Ms. Park, now I want to talk to you about Jesse Duran. Jesse never asked you for your gun, right?
No.
And Jesse never told you he wanted to hurt Sydney.
No.
And you never personally observed Jesse Park harm Sydney, did you?
No, but they played in a very disturbing way. Jesse was just very aggressive towards my daughter.
But you never observed Jesse hurt Sydney.
Not physically, no.
Ms. Park, now I want to talk to you about May 2010. In May 2010, you caught Sydney going through a foul drawer.
Yes.
And when you caught Sydney, you scolded at Sydney for being in that drawer, correct?
Yes, we stored a lot of our financial documents in there as well as the combination. And she was looking for a video game,
But that's right, you stored that combination in that file drawer.
along with a lot of other documents, yes.
And this combination was the combination to the safe.
Yes.
And in that safe, you held a 9mm revolver, right?
It was in the safe and it was locked, yes.
Now, Ms. Park, let's talk about that revolver. You purchased this gun in January of 2010.
After my home had been broken into, yes, I was very concerned about the safety of myself and my daughter.
And at the same time you bought the gun, you bought the bullets for that gun?
Yes, but they were stored in the garage. They were never stored with the gun.
Right, you said you stored the bullets in the garage, right?
Yes.
Now, Ms. Park, I want to talk to you about August 17, 2010. This was the first time that Sydney had approached you and asked for that gun, right? Asked you about your gun.
Yes.
And you didn't tell Sydney where that gun was, did you?
No, I informed her on the danger of firearms and that they weren't to be played with.
But Sydney assumed when she walked away that, I'm sure it's in the bedroom, right? You heard Sydney say that?
I'm not sure I know what she assumed, but my bedroom is very large, so
But you did hear Sydney say, well, I'm sure it's in the bedroom, right?
yes.
Now, Ms. Park, after you heard Sydney say that, you didn't move that gun, did you?
No, but I went to the gun, made sure it was unloaded, and then I made sure that the bullets were still in the garage.
And you didn't move that safe, right?
No, I thought it would be okay to just make sure that the gun was unloaded and that the bullets were stored separately.
And after Sydney
Your
asked
Honor,
you,
point of order, I just asked that I can move to see the witness.
oh, I'm sorry, I'll move.
You may certainly move.
Thank you.
You don't have to move.
And after Sydney asked you about that gun, and after you caught Sydney going through that file drawer, you didn't move the combination to that safe, did you?
No, again, the combination was stored among a ton of other files, and it was unmarked, and she was going through the filing cabinet to find a video game. I didn't think anything of it. Again, I just checked to make sure the gun was unloaded.
I understand this might be hard, Ms. Park, but I need the answer to the question. You didn't move the combination, did you?
No, I didn't think I needed to.
So on the morning of August 18th, 2010, when Sydney died, the gun was still in the safe, right?
Yes, it was stored safely in the safe in my closet.
And the safe was still in your bedroom,
Yes.
and the combination to the safe was still in an unlocked file drawer in the next room, right?
Yes.
Thank you, no further questions.
Any redirect based on that?
No, Your Honor, I just asked that the witness be excused.
Ms. Park, you may be excused. Plaintiff, you may call your next witness.
At this time, the plaintiff calls Dr. Solo to the stand.
Dr. Solo, you're aware that you've already been sworn in?
Yes, sir.
All right.
Good afternoon.
Good afternoon.
Please introduce yourself to the members of the jury and spell your last name for the record.
Certainly, my name is Dr. Campbell Solo. Solo is spelled S-O-L-O.
Dr. Solo, what do you do for a living?
I currently own my own therapy and consulting firm, Solo and Associates. It is a business that I started from the ground up back in 2003.
Well, what education do you have to hold this position?
I did my undergraduate work at the University of Oregon, majoring in psychology. From there, I pursued a medical doctorate at the University of Michigan, where I graduated back in '95.
Would you tell the members of the jury what experience do you have in the field of psychology?
I completed several residencies, both in Wisconsin as well as Midlands, finally accepting a position at the Breckenridge County Mental Health Center as an adolescent and child psychologist. And then after that, I decided to stay in Breckenridge County in Midlands, and I opened my own firm.
What qualifications do you have to hold such a position?
I am licensed to practice psychology in both Midlands as well as Wisconsin. I am a member of the American Psychiatric Association as well as the American Academy of Adult and Child Psychology.
Doctor, did you come to a conclusion in today's case?
I was able to, based on the facts and data that I was presented with, yes.
And what facts and data did you rely upon to come to your conclusion?
I was presented with several affidavits, statements, and exhibits as well, including those of Hayden Duran, as well as Andy Park, and the babysitter, Danny Brooks.
And did you use standard principles and methods in your field to come to your conclusion?
I did utilize the standards in my field for all of my analysis, yes.
And did you apply those standard principles and methods reliably to the facts and data in today's case?
I did, yes.
And now, Doctor, how did you begin your analysis?
Well, I began, my primary objective was to assess Jesse Duran's behavior and to see how that may have played a role in the happenings of August 18th of 2010. So I began by looking at Jesse's behavior. In doing so, I was able to identify several risk factors that Jesse displayed that are risk factors for violence in children his age, or her age, excuse me.
You say you found multiple risk factors in
Yes.
Jesse. What was that those factors?
Well, there were three of them specifically that I was able to identify. The first was that Jesse displayed previous aggressive or violent behavior. The second was that there was an extensive exposure to violent media, and also that there was a presence of a weapon, in this case a firearm.
Now, you just explained the three factors. I want to
Yes.
break those up and take them one at a time, okay?
Sure.
First, let's talk about previous aggressive behavior.
Yes.
What evidence did you find that indicated this?
There were several incidents that indicated there was previous violent behavior. The first of which was a disciplinary note sent home from school.
Objection, Your Honor. This would be hearsay as to what the disciplinary note stated.
Response?
Your Honor, no statement has been elicited at this time.
You repeat your answer for me there, Doctor.
I said that there was several incidents that indicated previous violent behavior, one of which being a disciplinary note sent home from school.
I haven't heard any specific hearsay statements from the disciplinary note yet. She might be relying on it for a little bit of her testimony, but until she tells us something specific from that note, we haven't waded into the hearsay waters yet. If she does start telling us things that were part of that note, feel free to re-object. Overruled for now.
Yes.
Now, you said there were several different instances. What was that besides the disciplinary note?
Well, in addition to the disciplinary note, there was also a death threat posed and a drawing made by Jesse Duran that were of concern as well.
Now, I want to break those up.
Sure.
Let's first talk about that disciplinary note. Would you
Okay.
recognize it if I showed it to you here in court?
I'm sure that I would, yes.
Permission to approach opposing counsel with plaintiffs to three.
You may.
Thanks so much.
You're welcome. Dr. Solo, what did I just say?
This is a notification of student discipline that was sent home by the administration of Jesse Duran School to the parent, Hayden Duran.
And is this a fair and accurate copy of that note?
Yes, appears to be the exact same as the one I relied upon for my research.
And did you use that note to rely on that note to come to your conclusion in today's case?
I did, yes.
Plaintiff moves to admit plaintiff 3 into evidence at this time.
Any objections?
Yes, Your Honor, at this time I would object to hearsay.
Response?
Your Honor, expert witnesses are allowed to use hearsay to come to a conclusion in trial, and this witness has laid the foundation that she used that note to come to her conclusion in today's case.
Response on those grounds?
Yes, Your Honor, she is allowed to use hearsay, but this would be being a conduit to hearsay by using this statement in order to give other statements about Jesse. This would still not be applicable under that rule and would still not be allowed in under 801.
Defense counsel, could you perhaps give me some applicable case law that would say using 703 in this particular matter is improper?
Yes, Your Honor. Specifically, we can refer to Terror Readers Association of Midlands versus Mayor Dow. And this specifically says that actually, we can refer to Richards versus Mississippi Barbecue, which says that the expert doesn't have an unlimited license to testify to hearsay statements, and that they can summarize the hearsay, but they can't refer to specific things within the hearsay document.
Plaintiff's counsel, can you tell me why this particular case law isn't binding in this case? As far as I'm aware, 703 allows the expert witness to testify to what would normally be considered hearsay, but they're not allowed to have an unlimited license with that rule, meaning that we're probably not bringing in documents that they relied on. She can certainly tell us what's in that document if she relied on it, but by submitting it to evidence under 703, it's not an exception to the hearsay rule, and doesn't make the document not hearsay. So you can persuade me that this case doesn't apply, or that 703 somehow allows us to admit this as an evidence. I'd like to hear that.
Well, Your Honor, actually, I would like to, instead of an exception, I would say that this is not hearsay. We're not using this document to prove the truth of the matter asserted, but we're using this document to say that Hayden Duran saw this document and did nothing. We're trying to prove the effect on the listener rather than the truth that it asserts.
You're trying to use that to show the effect that it had on Ms. Duran.
Yes, and that directly corresponds with her conclusion in today's case.
And that witness can tell us how Ms. Duran was affected.
Yes, because she relied upon Hayden Duran's affidavit in today's case to come to her conclusion.
Do we need that to be in evidence for us to understand how Ms. Duran was affected by it?
No?
All right, then this time I will sustain your objection. The witness is free to testify to how the document might have affected Ms. Durant. If you think they're stepping beyond that and offering it for its truth of the matter, or if they start to read specific portions and you think being a conduit for hearsay again, feel free to re-object. So sustained, you may proceed.
And sorry, just at this time, I would move to strike any testimony that was elicited about that.
I'm not sure that any was, but if it was, it will be stricken.
Yes.
Yes, Your Honor. And now, Dr. Solo, what did that note show?
Well, the notification of student discipline indicated, first of all, that there was an incident at school where Jesse Durant struck another child, and that this was not the first incident of Jesse striking another student.
And to your knowledge, how many instances were there?
The notice indicated that there were at least 3 incidents within 1 school year of Jesse striking another student and being caught by a school administrator.
Now, Dr. Solo, to your knowledge, was Hayden Durant aware of this?
To my knowledge, this note was sent home from school, signed and sent back to the school administration by Hayden Durant, so yes.
And to your knowledge, what was Hayden Durant's response?
There was no indication that Hayden Durant responded in any way except for to confirm that Jesse did in fact strike the other student. There was no indication, as far as I'm aware, of any sort of discipline at all.
And now, Dr. Solo, you also mentioned a picture that Jesse drew. Would you recognize that picture if I showed it to you?
I would, yes.
May I approach opposing counsel with please support?
You may.
Thank you.
Dr. Solo, what did I just hand you?
This is a picture that was drawn by Jesse Durant.
And is that a fair and accurate copy?
Yes, it is. It is the exact same that I relied upon.
And you relied upon that to come to your conclusion today?
I certainly did.
Plaintiff moves, plaintiff forwards evidence at this time.
Any objections?
No objections, Your Honor.
Then it will be admitted.
Permission to approach and to publish the jury.
You may.
Now, Dr. Solo, what did that picture show?
The picture indicated Jesse Durant in several separate instances, all while having a gun in hand, first pointing it at objects, second at animals, and most significantly, other children.
You said that she pointed a gun at other children. Why is
Yes.
this so significant?
Well, it wasn't really the gun itself that was of concern, more of the action of pointing a gun at other children. That is a severe indicator of fantasies about hurting other children, and that is where a parent should step in and take action.
Well, Dr. Solo, you mentioned a note, a picture, and you also mentioned a death threat.
Yes,
And now, who was this death threat posed to?
to Sydney Park.
And who made this death threat?
It was by Jesse Durant. Jesse said, "You are going to die. I want to shoot you, Sydney. Bang, bang."
And now, Dr. Solo, I want to move on to the next factor,
Sure.
violence in media.
Yes.
Now, what evidence did you find that indicated this?
There was an extensive number of violent video games present in the Durant home.
Why would you say they were violent?
Violent video games by nature, they're first-person shooter games that depict war, shooting other players within the game, crimes such as that. There's blood and other graphic material. They are rated for ages 17 years and older. That's the intended audience. And children should not be allowed to play these games, especially those with previous violent behavior.
Objection, Your Honor. I would object to lack of foundation, improper opinion, sorry. Improper opinion. We've heard testimony that this doctor is a psychologist, but we haven't heard any testimony that she has any kind of specialty in violent video games, that she knows how violent video games could affect children. We need to understand this before we can take her testimony as true in this case.
Counsel?
Your Honor, at this point, she hasn't said anything to the effect that it may have on the child. She just stated her opinion, and her opinion is that it's for 17-year-old, people that are 17 and older, which is the rating on the video games that she reviewed, Your Honor.
May I respond?
Response on those grounds?
Yes, Your Honor. Dr. Solo just testified to the fact that children who have a violent past should not be playing these video games. This is a conclusion that she made. We need to be able to hear more testimony that makes her a credible witness to make this conclusion. We haven't heard that yet.
One last response, Counselor?
Your Honor, she has stated that these games are for people that 17 years old and older. Now, if I may proffer,
You may.
It will show that at the time Jessie Duran was only 11, Your Honor, that is what she is concluding to, that children that are 11 should not be playing violent video games which were meant for people that are 17 and up.
What about her qualifications allow her to testify to this?
Your Honor, she has stated that she is a psychologist and she works with children, so therefore she would know about the violent behavior and if it tends to help or not help them if they play these type of games.
I agree. Your objection is overruled. If you think she goes beyond her expertise as a child psychologist, feel free to re-object.
Yes, Your Honor.
So you said that there were violent video games. Would you explain that again?
What violent video games are?
Yes.
As I was saying, they are violent in nature because they depict war, they depict scenes of crime, there is blood. Often there are other crimes involved with that as well. That can be very harmful to the psyche of a child, especially in the developmental years, which is why they're indicated for audiences that are 17 years of age and older.
And to your knowledge, at that time, how old was Jessie?
At the time that Jessie was introduced to these types of video games, I found evidence that as young as 10 years old.
Now I want to move on to that last factor, okay?
Yes.
Presence of a gun. And now, how did this affect Jessie?
Well, it is my opinion that due to the extensive exposure to violent media in the form of video games, it is the appeal of a real gun that brought us to the events of August 18th of 2010.
How so?
Well, once Jessie found out that there was a real gun present in the Parks home, she immediately expressed an interest in playing with it.
Who did she express these interests to?
Her mother, Hayden Duran.
And when were these interests expressed?
On August 17th of 2010, which was the day before the shooting.
Now, Dr. Solo, you talked a lot about risk factors.
Yes.
If a parent should see any of these factors in a child, what should they do?
Any parent who sees any one of these warning signs present in their child should immediately seek the help of a qualified mental health professional. Preventative measures such as therapy have shown to reduce or even eliminate the risk of violence in children of that age in the future.
And to your knowledge, when Hayden Duran saw these risk factors, what did she do?
I found no evidence that Hayden Duran did anything to take action against them, only saw the warning signs and failed to act upon them.
Dr. Solo, did you come to a conclusion based upon a degree of scientific evidence?
I was able to come to two separate conclusions, yes.
What was your first?
My first conclusion was that Jessie Duran was at an extreme risk for violent behavior long before August 18th of 2010.
And your second?
It was my second conclusion that Hayden Duran had more than enough information to assess her daughter's situation and address the violent behavior shown there.
At this time, I have no further questions.
Cross-examination?
Yes, Your Honor. At this time, I ask for permission to approach the jury and to retrieve evidence.
Yes, you may.
May I proceed?
Yes, you may.
Dr. Solo, I want to start by talking to you about this cartoon that you spoke about on direct examination.
Okay.
Sure.
Now, you would agree with me that this cartoon that Jessie wrote says, "This is me and my gun, scaring all the bad kids away."
Yes, pointing the gun at children, that is absolutely correct.
Well, not bad, but you would agree with me that Jessie was talking about scaring bad kids away.
That is what it says. I did focus on the fact that she was pointing a gun at children, though, yes.
But we can also see the fact that she was scaring bad kids away, not trying to hurt perfectly fine kids.
I'm not sure what classifies children as bad or perfectly fine. That is what is written on the document, though.
Okay.